Hello friends, in this video I am going to discuss common terminologies used during criminal proceedings. In the proceedings of criminal cases, certain terminologies are used. Significant of them are discussed in this video. The first one and the most common is F.I.R, that is the first information report. F.I.R is the first step under which a complaint of crime is filed by a police. More often, it is also considered as the first step of the investigation of a crime or offense by the local police. Next, that is warrant. Warrant is a document which is issued by the government official. Warrant authorizes the police or another such body to arrest the person in question, search such premises related to him or her, or carry out some other action related to the administration of justice. Next, bail. Bail is a temporary release or secure the release of a person, accused, prisoner, on the payment of a security amount. Next one, that is bailable offence. The offence in which a bail can be granted after fulfillment of certain conditions is known as bailable offence. In case of bailable offence, the police is authorized to give bail to the accused at the time of arrest or detention. Next one, that is non-bailable offence. The offence in which a bail cannot be granted even after fulfillment of certain conditions as the matter of right is known as non-bailable offence. However, in such a case, a competent court can grant the bail. It is important to note that the grant of bail even in a non-bailable offence is subject to judicial discretion of the court, and it is important to note that the grant of bail even in a non-bailable offence is subject to judicial discretion of the court, and it has been mandated by the Supreme Court of India that bail not jail should be the governing and guiding principle. Next one, that is cognizable offence. The offence in which a police can arrest the person accused without the warrant is known as cognizable offence. Next one, that is non-cognizable offence. The offence in which a police cannot arrest any person without the warrant is known as non-cognizable offence. Next, that is anticipatory bail. On an apprehension of the arrest, especially on a wrong accusation of committing a non-bailable offence, a person can apply for the bail before the competent court is known as anticipatory bail. Under Section 438 of the CRPC, a person who apprehends arrest on a wrong accusation of committing a non-bailable offence can apply before a competent court for a direction to police to immediately release such a person on bail in the event of arrest. However, the grant of anticipatory bail is discretionary of the court and depend on the nature and gravity of the accusations. Next, public prosecutor. In reference to criminal case, a public prosecutor is a state counsel whose key duty is to conduct prosecutions on behalf of the state. So, a public prosecutor stands against the accused in the court. Last but not the least, that is defense counsel. In reference to criminal case, a defense counsel is a pleader who stands for the accused in the court and ensure a free trial. So, defense counsel defends accused in the court. It is every accused's basic right to have a pleader who can defend his or her rights. In a case where an accused cannot afford a pleader as he/she has no money, then it is duty of a state to provide him or her a pleader.